The legal landscape surrounding email signatures in South Africa is primarily governed by the Electronic Communications and Transactions Act, or ECTA. This act gives legal recognition to electronic transactions and communications, clarifying their validity and enforceability. ECTA recognizes two primary types of electronic signatures: ordinary electronic signatures and advanced electronic signatures, or AES. An ordinary signature can be as simple as a typed name, while an AES is a more secure form accredited by the South African Accreditation Authority. Section 13 of ECTA states that if parties haven't agreed on a signature type, a reliable method identifying the person and indicating approval is sufficient. The Supreme Court of Appeal case S. Spring Forest Trading v. Wilbury highlighted how a standard email footer could amend an existing agreement. This case confirms that even non-variation clauses in contracts can be overridden by email exchanges if the footer is intended as a signature. An AES is required when the law necessitates a signature without specifying the type, such as for contracts of suretyship or copyright assignment. However, electronic signatures may not suffice if prohibited by law, if an AES is specifically required, or for documents like handwritten property contracts and wills. Professionals must be cautious when discussing contract terms via email, as ambiguous language can be interpreted as a binding agreement. Email signatures can also increase cybersecurity risks, as detailed personal or organizational information can be exploited for phishing or fake invoices. Implementing robust security measures, providing employee training, and regularly updating disclaimers are crucial mitigation strategies. Always consult with qualified legal professionals to ensure compliance and appropriate security measures for your electronic agreements.